is that the developer be charged with payroll as opposed to the committee has found instances of 3 different ways for payment of this. We don't, or I certainly would be willing to say I don't have sufficient knowledge to be able to say one is better than the other.
Some communities, any community you know right now, have a pool from which they could draw funds for payment like this?
That was Huron?
Yeah, Huron County, yeah. You know, another thing, I was just working with Meridian Township where I live, on their ordinance, this may not satisfy you, Cliff. What they wrote in was basically the township will make a decision first about the complaint, kind of the legitimacy of the complaint. And then if that determination is made, then the owner of the wind system is obligated to pay for the study. The thinking being that, I think you raised a concern about
Frivolous.
right. I didn't want to use that word, but and so the assumption being in that case, the township was kind of going, now wait a minute, you know, we just had a similar complaint from Jones, and now there's the same complaint from Smith, and we're going to do another study. We did the study after the first complaint. Does that help?
Why don't you, Mark, give me your wording, and by early next week, I'll get this recirculated as another draft, and part of the other things we're going to do then, and see where we stand. We'll have plenty of time before the next meeting to put together a further draft before we talk about this again.
Would you like to hear comments from the public at all on this before you move on to something else? Or?
What's the pleasure of the group?
I'm fine with public comment
Okay.
now.
Fine with me? Yep.
Okay, thank you. Well, my name is Evelyn Vergala, and I mean, we're facing this in our community right now in Mason County. And they're reviewing the complaint resolution. And I guess one of the things that, you know, I hear a lot about frivolous suits or frivolous complaints, and that's always brought up. But, you know, from our point of view, as the communities, we have a problem with, it'll most typically be noise, and the fact that these large companies can do things remotely, can feather down blades, can slow them down if we wanted to complete a noise study. So, I mean, how do we control what happens during noise testing if the developer is in control of doing their own kind of complaint testing? So, I mean, one of our issues is, I'm assuming before you get to mediation, or community resolution, that there's some kind of studies being done, and maybe it's the developer that's doing the studies on a complaint. We would always, I think I would always figure that they're compliant. You know, they can figure out how to be compliant. So, I mean, just as you can say that there are frivolous complaints, I could say there are developer methods for beating that system. So, I mean, it's a little bit, I mean, I find that pretty much derogatory, probably from both directions maybe, but at the same time, there's not much of a level playing field. These are billion-dollar developers, and I'm a resident with, you know, a fixed income, and how do I mean, is it only the rich can complain? Is that the way this complaint process goes? And yet we, you know, somehow have to have a system by which we can feel sure that the developer, that we're going to have some possibility of arriving at in the early stages. Why have to wait to get to community resolution or mediation? I see that as kind of hopefully the extreme.
So can I just offer one thing?
Sure.
People I know that are in the community dispute resolution business, they would say you should bring us in at the planning stage.
Okay, okay.
Right. So when issues like how do you do wind sampling, that methodology is established early in the process, not after.
Before the project goes.
Before the project goes, at the initial discussion stage, that's when these discussions should happen. And I think if you look at what has happened in Gratiot County, that kind of discussions have gone on. But people in the community dispute resolution, they would be the first ones to say, bring us in up front.
kind of what, Mark, I'd like to remind you that Gratiot County is one county in Michigan, and many counties actually have ordinances in place already. So I think that would be a perfect and ideal world, but we're talking about a different stage of development. Sometimes people aren't looking for this until there's already a development being reviewed in their community, whether or not the ordinance is in place or not. So I think we need solutions to solve things that are occurring.
I think you have to, I was trying to respond to this question here of how do we do that? So in an ideal world, you would do that now in many communities. So now we're at the next step, which is we go from that to litigation or arbitration or back to dispute resolution.
Well, but, I mean, I want to make it clear, what this says is an independent investigator, because I think addressing the issue.
Is that after, I guess maybe because I'm not involved with what the draft actually says, do you outline anything, steps before that, or are you just tacking this on, you're expecting this to kind of happen after, let's say, the developer proposes a complaint resolution process and that somehow fails and the complaint continues? Is that
Well,
when
again, each community makes their own rules. So let's just say for the sake of argument that a community has a complaint resolution process in place. That may or may not include community dispute resolution. It may be take it to the courts. It's up to the local community to decide what that resolution process is. I don't know of any agreement with a developer that does not include some sort of dispute resolution language in.
Yeah, usually what it says is have the developer come forward with their own complaint resolution procedure. That's what many of the ordinances
Absolutely,
say.
I think you are absolutely right, that's the case.
Which kind of basically leaves us at the kind of behest of what the developers come up with.
And just to clarify, the sample zoning language has exactly what you just said. So this would be a change in two ways. One is suggesting a voluntary mediation process at any stage of the process, and then kind of a formal municipal use of an independent investigator process. So there would be kind of two changes to what we have now.
One thing, a couple things we haven't mentioned that are in our paragraphs, in our section on conflict resolution, are the idea that to minimize post-construction complaints, there might be some pre-construction things like, obviously upfront agreements is part of that, but the option of making good neighbor payments is one being exercised around the country by many companies who live within a certain distance from the nearest wind turbine. Another would be to make heavy use of overlay districts, which would keep turbines away from certain highly dense areas, and that's all part of the normal zoning rules. But we have addressed those things to that extent in this section.
Before we go on, does that answer your question?
Well, I mean, I guess what it sounds like to me what you're doing is you're looking at the stage of the complaint when it gets beyond the kind of initial, kind of like I've talked to the developer, I can't get any satisfaction, the noise is still ongoing, and now we're going to go to some kind of complaint, community resolution. It sounds like that. But I mean, I think communities are also still struggling just with wanting to understand, I mean, how do you deal with either what the developer has proposed in terms of their process, or a community struggling with those first steps of like, I got thumping noises at night, who do I call? There's a number to call. Who logs it in? Does the developer have to tell the county? How does the county find out? Does the county then, are they involved at all? Or do they just stand back and they let me and the developer wrangle it out? How many times do we do that? Over, is it 30 days long until we kind of get the end of the point of where I can't stand it anymore? And at that point, does the developer, are they doing their own testing during that time? They hire a sound consultant and I'll be darned, it comes out compliant every time. I mean, I don't know. I think those are the things that they're grappling with.
I hear what you say. I think that's a very legitimate concern. You're speaking about yourself being from Mason County.
Yeah, I mean,
where
we're doing it right now.
the stage is, what stage are you in exactly right now? I know the community's
Well,
talking
turbines are
to.
turbines are proposed for our area. We've presented amendments to the ordinance because it basically had if I want to make a complaint, this is the way our ordinance is written now, if I want to make a complaint, I have to go put money up in escrow to hire a sound person to see if the developer is compliant or not. And we're contesting that, and we're saying that's not right. You
So
shouldn't
what
have
is your
to-
noise level by which, to which?
55.
Okay,
55
that
is the
is the
property line.
problem, I think.
Well, that's a
I
problem,
think-
sure.
I think what we're trying to do is bring that number down at least, and if you can get that number down to a reasonable level, the one that's acceptable to a large majority of the community, or most of the community, a larger segment of the community, then we've made some progress here. But if you're dealing with one company that's coming in with an ordinance to keep it just to 55, then you could have some real problems down the road.
Sure.
So that, I think your question underscores the necessity of our group to do something as soon as possible about bringing that noise level down.
Right, thank you.
And I know there are several hands. I saw yours.
Mark had a point about working with the developer early in the stages of the program. I'm from Hillsdale County, and what happened was a developer came in 2 or 3 years ago. They started getting all these contracts with farmers pretty much on the quiet. Nobody really knew what was going on, especially the people that had a 2-acre parcel or a 5-acre parcel. They weren't talked to. And our county, talked to the county, they don't have zoning. You go to the townships, half of them have zoning, the other half don't. It's about in that proportion. I think one county actually developed their own ordinance where they had noise limits less than 55. One out of, I think we've got 13 townships, something like that. Most of them picked up the state guidelines, exactly as they're written. 55 dBA and 1 height of the turbine away from the house. That's it. People don't know what's going on. They really don't. There really has been not too much in the paper. People, you talk to people on the street or a church, say, do you know, you heard about the turbines coming in? No, they haven't got a clue. And these people are all through what they're doing now, since Reading has an ordinance, which is 45 in the overlay, 40 at the fence lines where they do not have contracts, and then outside the overlay 35. What the developer's doing is running around and signing good neighbor agreements to everybody in the overlay to get it up to 55 so they can put them closer together. $1,000 or whatever it is per person.
Excuse me, don't look at me, I'm not the developer in that area. You're pointing at me.
Well,
Don't do that.
I know you're not. But that's the problem we have, though, and people don't understand what's going on. And my fear is people are going to come out of the woodwork once these go in, and they're going to have a lot of problems. If you look at
That's
noise,
verified by what's going on around the country. I agree with you personally.
So what, I'm just curious as to what you think is the way to resolve that.
we need a much better ordinance, or we need a much better set of guidelines, and we need better ordinances with much lower limits on noise and bigger setbacks.
Okay, so we are in the process of developing a new set of guidelines. It is completely and utterly up to the local governments whether they choose to read them, accept them, adopt any or all
But
of that part of the
remember,
ordinance.
they're picking those up and they're running with them.
Then you have to go to your elected
I know ones that
officials.
aren't.
Well, I've got going to where I live at, I don't have any, there is no zoning in my township. And I've talked to them and they say, we're not even talking about it.
Then go somewhere else.
We don't do anything.
They trust
But they trust the
guidelines.
state.
Yeah, they
Right.
trust the
Set
state.
guidelines that are
Absolutely.
That's their
reasonably
only
protective of their health. That's what we're
They
doing.
really look to the state to set guidelines that will protect them.
So we cannot set guidelines, but we are rewriting the recommendations that, if you go back several years ago in the process of getting to the recommendations that are out there, It was reaching out, getting the best available information and best practices available to get those guidelines out there. They're now in their third set of revision to do exactly what you're asking. So are you, I want to know, are you asking us to do more than we're doing now? 'Cause we
I think
we're
you're
doing
in the right
stuff.
direction, but
Okay.
I look at what you did a couple years ago, putting the state guidelines together, 55 dBA, and I went through in detail. And I went back and looked at the Lawrence Institute of Technology studies, and you never picked up anything they told you. They had in there, I got that right here. This was the report by one of the guys.
What year was that?
This is by